Well, hello, this is Ray Ferrara, CFP, and your host of the Up Your Assets podcast. As 2025 unfolded, the estate planning community was facing the sunsetting of the 2017 tax law that temporarily modified the amount of money a decedent could set aside at death to avoid estate taxes. Uncertainty reigned. Fortunately, by the middle part of 2025, Congress passed and the president signed the so-called One Big Beautiful Bill, which made permanent the estate tax rules. Now, to be fair, it is permanent until a future Congress changes it again, but at least there's no sunsetting provision. If you want to learn more about the entire One Big Beautiful Bill, visit our website, upyourassets.org, to see our podcast about it. The changes are so extensive that virtually anyone, regardless of the size of their estate, needs to evaluate potential changes to their estate plan. To help us today, we have Nick Grimaudo, who is an estate planning attorney with Johnson Pope, Boker, Ruppel, and Burns, based here in Clearwater, Florida, with offices in Tampa. Please keep in mind that this podcast is educational in nature and is not designed to provide individual advice. Please consult with your own advisors. Nick, welcome to the Up Your Assets podcast.
Thank you for having me, Ray. Appreciate and pleasure to be here.
Nick, why don't you share with our listeners a little bit about your background on both a professional and personal level?
Sure. So I'm originally from Florida, from a small town, Inverness, up towards the Ocala area. I went to the University of Florida for law school, undergrad, and LLM, which is a master's in tax law. And I've been practicing for just over 15 years here in the Clearwater, Tampa Bay area at Johnson Pope, as Ray said. And I specialize in estate planning and corporate transactions.
Okay. Well, Nick, let's jump into the questions because there's a lot of territory to cover. At the most basic level, what documents do you typically recommend that clients consider?
Sure. Great question. So one set of documents that a lot of people, when they come in and want to discuss estate planning, that they forget about is what we call advance directives. And these are living wills, healthcare surrogates, and powers of attorney. Each state has their specific forms or, required information in those documents, but those are almost equally or more important than your will or trust, which take effect only upon death or it's usually death, and sometimes your trust incapacity. What the advance directives allow you to do is essentially not have to go to court if you become incapacitated. If you become incapacitated, your family would have to go to court and have a guardianship over your person to essentially make healthcare and financial decisions for you. So these documents allow us to circumvent the court system and the guardianship arena, and allows your individual fiduciaries to make those decisions on your behalf. So those are very, very important documents. And then we usually will talk with a client and determine whether they need just a will or if they would like to explore a revocable or living trust. And the main difference between the two is really just whether you have to go through probate, the court system upon death, or if there's more of a seamless transition with a revocable living trust.
Yeah, and that's really important because probate can be expensive. It takes a lot of time, and it's a very public process. Most people don't realize that a will becomes a public document once it's filed in the court, where the revocable living trust will avoid all of those negatives, at least for those assets that are inside of the trust.
Exactly. And one of the things that we see usually if we're dealing with a probate or a trust administration after an individual passes away is some attorneys and clients don't realize just having that revocable living trust in place does not actually avoid probate. You actually have to fund that trust or have the trust be the beneficiary of accounts that we want to avoid probate. So the funding of the trust is equally as important to avoid probate, because a lot of clients think, oh, I just have a revocable trust, there's no need for probate. But unfortunately, if asset titling, which I know you want to talk about, through this as well, is not done correctly, you still may have to go through probate when a loved one passes away, even if they have a revocable trust.
Well, a lot of people struggle to start to do these documents in the first place, and then others maybe do them, but they think it's a one and done.
Mhm.
So, how often should one consider reevaluating and modifying their documents?
We usually recommend at least taking a look at the documents every 3 or 4 years to determine if the provisions that the client has in their documents are still their intentions. And then we usually recommend, if there's any life changing events like divorces, deaths, births, those types of things, that they reconsider and look at the document at that time to see if there's any changes they may want to make. The other thing is, if the client has an attorney, usually your attorneys, will let you know if there's any big changes in the laws, like the bill we're talking about today. But if they don't, I would recommend maybe contacting your attorney and asking them if there's anything based upon the new legislation that you should consider.
Well, Nick, let's jump in now specifically to the one big beautiful bill. Um, what is the new estate tax exemption per person? What was it in the past, and will it change in the future?
Sure. So right now it's in January, effective January 1, 2026, it's $15 million per person. And that will be indexed for inflation each year, which has been typical with any estate tax exemption in the recent legislation that we've gone through. And so that's usually, $100,000 or so increase each year. But the IRS will put that out usually around October or November of each year. Last year it was technically 13.9 million. So we've essentially got our, 1.1 million increase this year. And as you said in the intro, this is supposed to be permanent, but it's as permanent as anything can be with our legislature. If another Congress and Senate come in and decide to change it at a later date, it's subject to change, but at this point, it's permanent with no sunset. And the concern with prior to the beautiful bill, is that there was going to be a sunset. And so that technically, if there was no bill passed this year, the exemption would have went down to 7 million, because it would have sunset it back to the prior laws. So at this point, we at least know we have 15 million for the foreseeable future.
Oh, that's great. Well, 15 million, that's per person, so $30 million per couple. And that 15 million is an awfully big number and only affects a small percentage of individuals. What concern should those folks that are below the 15 million be thinking about?
Yeah, so the bigger concern for people below the exemption amount is not the actual estate tax itself. The more concern that we look at, and clients under that amount should be thinking about, is actually the income tax ramifications of their planning for death. So one thing that the new bill kept in place was what's called a step up in basis. And what that means is, when an individual passes away, any assets that they own, whether it's going through a will, through probate, or a revocable trust, those assets will get a fair market value basis for income tax purposes. And so that's important, because you don't want to gift or transfer low basis assets unless you have to prior to death, because you may actually be having a tax impact and income tax aspect impact to the beneficiary you're transferring to during lifetime. So we usually look at, with clients under the threshold, which unfortunately for a lot of our clients, it's a lot of them. It's one of those situations you wish you had an estate tax issue, correct? I mean, it's a high number, like you said, Ray. So we actually focus more on liability for the beneficiaries, if you want to look at liability protection and that income tax ramifications, to make sure that we're not inadvertently doing something that would get rid of that step up in basis.
So let's be clear that all you were just talking about were most of the states, but there's 7 or 8 states in the country that work with community property.
Mhm.
And one of the benefits of community property is you generally will get a double step up. You'll get a step up at each death. Recently, here in Florida, a law was passed to allow for a community property trust, which allows for that double step up. Do you make that recommendation for the people that are setting up trusts and might have highly appreciated assets, particularly if it's a business?
Yeah, so we kind of have to look at the impacts of the community property side. So in Florida, like you said, Ray, you can do the community property trust. The potential issue that we have to look at for clients is in Florida and a handful of other states, we have what's called tenancy by the entireties, which is really important because it provides a lifetime layer of liability protection for the spouses. And so what that means is the creditor of one spouse cannot attach the assets that are held as tenancy by the entireties. So I like to say that it's essentially a legal fiction under Florida law, and some other states have it, like Texas, where essentially the married couple tenancy by the entireties is a separate person. And so one of the things in Florida when we have clients that we would potentially consider the community property trust is by putting it in a community property trust, you do get that double step up in basis, as Ray mentioned. But we want to make sure that we're not getting rid of that liability protection under Florida law for tenants by the entireties. And so usually with clients, we sit down, and if we want to do that community property trust, we make sure that there's significant insurance coverage and things like that to mitigate the risks of breaking up that tenancy by the entireties. But it is a really big income tax planning mechanism to do the community property trust.
Well, while we're talking about titling assets correctly, it can certainly make a big difference in reducing probate administration. Um, and as we've been talking about, has both income and estate tax implications. Now, in Florida, as you were talking about, we have that tenants by the entirety, and usually um, we think of that as when we buy real property, like our home, is the way we set it up. But to your point, you can set up brokerage accounts the same way. You can own other assets in the same way to build up that asset and liability protection. So thanks for explaining the difference between community property and titling it in a different way. Well, if we let's just say my wife and I, if we have joint debts, say credit cards, signed loans, maybe notes that we co-signed for the kids, etc., can that pierce the tenants by the entirety protection?
That's a great question. Unfortunately, if it's a joint debt where both spouses are on that debt, the creditor can attach tenancy by the entirety assets. So it's not a perfect fix for every situation because you're going to have certain debts that both spouses are on. Like you said, co-signing loans, things of that nature. So it's good for individual creditors, but if it's a joint creditor, unfortunately, tenants by the entireties doesn't really help.
So to be clear, if I own the property as tenants by the entirety and I'm going to borrow money, it's best to borrow the money just in my name, not in anything where both my wife and I are jointly responsible.
Correct. If you can do it in that manner, that's highly recommendable. Yes.
Yeah, unfortunately, Nick, as you and I know, banks want more signatures, not less signatures when we borrow
Exactly. We
money.
like to talk in a perfect world, but unfortunately, most of the time, we're at the mercy of the banks who want everybody they can have on that loan.
Let's be a little more specific for a minute. Let's suppose that I own a business, which of course I do. Should I hold the corporate shares as tenant by the entirety to prevent a business um, account, let's say, um, opening up me to personal creditor or and seizing the entity, or what happens in that regard?
Sure, great question. So we have to look at, and each state is different, but essentially what you look at is the state law um, type of entity. Okay. So specifically, you're referencing corporation, which is if it's a corporation under state law, then we highly recommend owning the interest as tenants by the entireties. And the reason for that is shares in a corporation can actually be attached by a creditor, and the creditor can become an owner of the corporation. And so it's very important in that situation with an actual corporation that it's owned tenants by the entireties. When you look at an LLC or a partnership under state law, those in most states have what's called a charging lien. So what that means is that your creditor actually cannot become an owner of that entity. What they can do is essentially get a charging lien against that interest, meaning if there's any distributions from the interest from the company to the owner, they would get potentially paid back on their judgment. Even with those interests, we generally will recommend owning those tenancy by the entireties as well, just for the fact that if it's an individual creditor, they can't even get that charging lien because it's a tenants by the entireties asset.
Well, obviously, tenants by the entirety is a powerful way to own assets, given the asset protection that comes with it. But what if you move those tenants by the entirety assets into a joint revocable trust? Does the trust language satisfy the tenants by the entirety preservation requirements to maintain creditor protection, or is that now also a negative for having a revocable trust?
Yeah. So unfortunately, Florida does not have any laws that specifically authorize a tenancy by the entireties trust. So we have that community property trust, but we don't have a tenancy by the entireties trust. And so a lot of lawyers think if you transfer the assets from tenancy by the entireties to a joint trust and you have all the proper language in there, that it should continue the same tenancy by the entireties creditor protection under Florida law. Unfortunately, there's some cases out there in Florida courts that have ruled that transferring it to a joint trust breaks that tenancy by the entireties ownership and now puts it in what's called tenants in common, which essentially means that each spouse owns 50% of those assets, which is very similar to how community property is treated for creditor purposes. It's essentially seen as you're both grantors of the trust and trustees. And so 50% of the trust theoretically is exposed, unless the caveat to that is unless you can trace that it was truly your asset that you put in. Then you could have, argue up to 100% of that ownership is on the husband or wife's side.
So, Nick, in a typical spousal situation, um, husband dies first, leaves it to his spouse. The wife dies first; she leaves it to her spouse, and then after they're both gone, the money's going to filter down to the children and to the grandchildren. Kind of the natural order of things. But every once in a while, situations come up, and we've certainly seen some of those with some of the unfortunate large disasters that have occurred, both within the transportation industry as well as natural disasters. What considerations need to be considered if a couple were to die together?
Yeah, that's a great question because especially talking about the tenancy by the entireties, there's rights of survivorship on those assets, meaning that, like you said, if the husband died first by operation of law, it goes to the spouse. And so if they die, if the couple dies together, there is technically no operation of law where the asset will pass. And so that's something that we discuss with clients. And what I've seen recently, it's becoming more common, is that with those joint accounts, different banks and financial institutions are actually allowing a beneficiary designation to be made on those joint accounts. And so that's something I recommend before we even draft up, a joint trust or any trust, is that if there are those types of accounts, that we talk with the broker or the client, if they want to on their own, speaks with the broker or the contacted the bank to see if that is allowed, because that would essentially make sure that they both died together, that those assets are not going through probate and would go to either the designated individual beneficiary or the trust that we designate as the beneficiary. The other
So,
important aspect to think about there as well, Ray, is that technically the tenants by the entireties is a great way for creditor protection, right? Like we talked about. But if the spouse dies that did not have creditor issues and now it's in the surviving spouse's name and they have all the creditors, now all those assets are exposed. So it's not a you know a what's that panacea or something that covers everything. We've got to look at it in each situation and determine whether we want to do tenants by the entireties or not, considering those situations.
so when I own assets either as joint tenants with rights of survivorship, or tenants by the entirety, both of which go to the surviving tenant, if you will. It would be great to talk with your financial advisor and to find out whether the custodian can add transfer on death or payable on death to a beneficiary, then guaranteeing that those assets would bypass probate entirely. Is that what I heard you say?
That's exactly correct, Ray.
Okay. So suppose I own a business again that makes up a large part of my estate. Are there additional concerns that I need to be thinking about?
Yes, and there's a couple. Well, we talk kind of the operation, I guess, if you will, of the business. One of the things that some of our we got to talk about with clients is, if you want to leave that asset to all the beneficiaries equally, that might not always be a great idea because now they're all owners of the business. And so we got to think about the actual operation of that business once the individual passes away. So if you have, one child that may be in the business and two other children that are not, it might not be a good idea to leave it to them equally because now, depending on the corporate documents, the two that are not in the business can essentially outvote the child that is running the business and essentially kick them out. And that could be a big issue because we've seen with some of our clients where they don't know what they're doing, right? And so that's why a lot of family businesses will fail in the second or third generation because of not knowing the actual business. So some of the key considerations that we think about and talk about with clients is you can technically hold that those business interests in a continuing trust. Let's call it a business trust, where technically all three of the children are beneficiaries of it, meaning they would get the income and benefits of the cash flow of the company. But the child in my example that actually knows how to run the business would be the trustee and would have essentially the voting power of 100% of the ownership. And so it's very important to think about that as part of the succession planning for the business.
So, Nick, so I've got this huge asset that's a significant part of my estate. And let's say I'm over the $30 million limit with my total estate, or $15 million limit, I should say, at an individual level. Um, uh, are there any special rules that come into play as to how I might have to be able to pay those estate taxes if a business represents a significant amount of my wealth, but I don't have the money to pay all the taxes today?
Sure. Now, yeah, great question. And so there is an internal revenue code section that allows the estate to essentially make an election if it is taxable and there is taxes owed. And what you can do in that situation is you can make the election, and then the estate tax that's directly related to the business interest is able to be spread out over up to a 14-year period. And so what allows you to do is not have a fire sale essentially of assets or the business to pay the estate tax because the tax is due 9 months after death, even though you can have an extension to actually file the return up to 15 months, that tax is still due 9 months from date of death. And so we've utilized that for some clients that it has to be an operating business. So if it is an operating business, a true business, then you can make that election. If it was just essentially a holding company, like a family partnership, you can't make that election. So that's a consideration. Now, there is interest that is charged. It's not, essentially just we come up with the number and we pay that prorated over the 14 years. So there is an interest component that has to be taken into account. But we also discuss with the client if there's the ability to have, insurance proceeds, whether we get that through a second to die policy, if there's a married couple that would go into some sort of irrevocable life insurance trust. That's a way to at least pay some of the tax, and then we can, defer some of the other tax, that 14 years. That's kind of what we look at when there is a substantial asset like a business.
And so important to point out, you talked about a second to die policy. For those that are not familiar with it, in a life insurance policy, it pays off obviously when somebody dies. Um, and you could certainly buy an insurance policy on each spouse to help pay for that. But under current tax law, when a spouse dies, if the decedent spouse leaves everything to the surviving spouse, then there's no estate tax that's owed, regardless of how big the estate is. In most cases. Um, a second to die policy says it doesn't pay after one death. It has to be after both deaths. And as a result, that type of a policy is far less expensive than buying two individual policies to help pay the estate taxes. Um, so one of the things to consider if you do have a large estate and know you are going to have to pay that estate tax, you basically are going to pay it all up front out of the estate and leave the net proceeds, or you might have some life insurance that's set aside in a trust, which would not be included in your estate, and then the trust could buy the assets out of the state to provide liquidity to pay Uncle Sam, because as Nick commented earlier, Uncle Sam wants to get paid within 9 months of your death. So something to consider and chat with your advisors about in the event that your estate is over the $30 million level. So Nick, recently there's been a lot of conversation about of what is called a SALT, or I should say a spousal lifetime access trust, a SLAT, not a SALT. SALT's another deduction we have to worry about. Um, when should this be considered, and what are the benefits of having a SLAT?
Sure. So the SLAT is very powerful tool if you have kind of two situations. One, if it's a younger couple that it has significant assets that are definitely going to be appreciating over time. And what the SLAT allows you to do is to form, it's an irrevocable trust. So that's something to consider. It cannot be changed. It's not like the revocable trusts we were talking about, revocable living trusts. So one spouse, which we'll call the grantor, sets this trust up for their spouse. And what this SLAT allows you to do is to contribute assets to that trust and to essentially utilize your estate tax exemption, because it's a unified estate and gift tax exemption. And so you can use up to that 15 million now, and you're getting that into the irrevocable trust, which the spouse is the primary beneficiary of. And so that's great for two reasons. One, we're getting that money out of the taxable estate of the grantor. So if that 15 million grows to 30 million when the grantor spouse dies, all that appreciation is never going to be subject to estate tax. So that's very powerful. The other thing is the surviving spouse or the spouse beneficiary can actually be the trustee, meaning in control of those assets that were contributed, and they're the lifetime beneficiary. So the couple is not giving up essentially the income and distributions from those assets. And so you can technically still live off of those assets while the beneficiary spouse is alive.
All right. So another great way to delay and perhaps eventually not have to pay any estate taxes at all, just depending, of course, where the estate goes until the second death. All
Yeah,
right. Well,
and what
let's.
you can do too, right? If the clients have already have that 40-50 million dollar wealth and can continue to grow, each spouse can actually set one of these trusts up. Now they cannot be exactly the same, The Internal Revenue Service has, and the Internal Revenue Code has what's called a mirror trust provision. So you cannot have mirror trusts, or else they will essentially invalidate those trusts. So estate planning attorneys like myself, we will make sure that there's certain provisions in those documents or different trustees, things like that, so that you can technically both utilize your exemption as a married couple without fear of those trusts being disregarded by the IRS.
Right. Let's dig a little deeper. And again, want to look at the larger population for a moment. And let's assume that my spouse and I are below the $30 million exemption. Do we really need a complex trust, or are there other ways for us to minimize our potential estate taxes?
Sure. Yeah. So if you're under the 30 million, you don't necessarily need a complex trust that has what we a lot of times refer to as marital and family trusts, and all those types of provisions in it. There's two options that we kind of currently have under the current estate tax code. There's what's called portability, which as was brought over into this bill as well, that's been in the past. And what portability means is if one spouse passes away, whatever estate tax exemption that is unused by that spouse can actually be claimed through filing an estate tax return and added to the surviving spouse's estate tax exemption. And so that there's no fear that by not having these complex trusts that we're essentially losing the first spouse's exemption. That helps, but one of the issues with the portability exemption is that it only applies to estate tax. It does not actually apply to generation skipping transfer tax, which is another tax that our wonderful government imposes if assets that are held in trust or not in trust that are essentially going to a two generations down from the decedent. So what that means is if it's grandchildren or beyond the gift or the distribution, that portability exemption would not apply to those distributions. So that's not the only option we have. As I said, there's two options. The other option that we usually employ in these types of situations is what's called a disclaimer trust provision. And what that allows for is if it's set up in a will or trust, it has a specific provision that it says essentially everything goes to my surviving spouse if they survive me. And then that spouse has the ability under the Internal Revenue Code and the trust or will document to disclaim a portion of those joint assets or assets that they are going to inherit. And those assets would then essentially be held in a separate trust for the benefit of the surviving spouse. And what that does is it allows us to utilize the first spouse's estate and GST tax exemption at their death if we so choose to. So even for clients that are not anywhere near the 30 million, I still like to recommend putting that disclaimer trust in their documents to give us that flexibility on the first spouse's death.
Right. Now, you use the word or an acronym GST, Generation Skipping Trust. Um, and so just point out at this point that that's a way to skip a generation with a certain amount of money so that it doesn't have a double estate tax. Once I pass it to my children, on those assets, my children, it would not be part of their estate because it would have skipped onto to the grandchildren. Let's think for a moment that what are some ways that I can reduce my estate, particularly if I am close or I have a long enough runway that I think it might get over that. What are some of the things I can do or should be talking to my advisors about without getting into too much detail on some of those ideas?
Yeah, so we talked about the slat, which is a great way to potentially limit that exposure. Now, if it's an individual, obviously doesn't have a spouse, we can't do that. The other things that are I would like to call low hanging fruit that is easy to utilize is there's an annual exclusion from gift tax and estate tax which means essentially there's a value or a fair market value number of $19,000 per recipient that any individual can gift each year without having to file a gift tax return, and it does not eat into or reduce your $15 million exemption. And so, what a lot of our clients will do is essentially give that $19,000 a year to each child, their spouse, potentially to grandchildren. Through, if they're minors, you can either set up a trust for them or just utilize uniform transfers to Myers Act type accounts. So you can put that $19,000 a year and essentially get that out of their estate. The nice thing is that it's per person. Technically, um, each spouse can give that $19,000 a year if they're married, and so you can essentially give $38,000 to each individual that you desire to get that money out of your estate.
And Nick, let me stop you at this point. One thing really to clear up, I hear this all the time. Well, what if I give? What if I give more than the $19,000, or I don't want to pay more than the $19,000 because I don't want to pay a tax. I don't want to pay that gift tax by going over the annual limit. Let's suppose that I'm going to help one of my children buy a home, and I'm going to gift them $100,000. What am I going to owe in gift taxes since I went over the $19,000?
So, as long as you have not utilized your entire exemption, what we have right now under the current regime is it's a unified estate, gift, and GST tax. And what that means is that that $15 million exemption can be used at death or can be used during your lifetime, but you only have $15 million. And so, in your example, if you gave $100,000 to one of your kids, you would essentially reduce that by the 19,000. So we'd be at essentially $81,000 of quote unquote taxable gift. Now, there's no gift tax due on that, like I said, as long as you haven't used your entire exemption. And so, what you would have to do is get with your CPA or attorney if your attorney files these returns, and it's called a Form 709 gift tax return. And what you're doing is essentially just letting the IRS know that you used some of that $15 million. There's no tax due as long as that exemption still exists in your case. And it essentially just lets the IRS tally, okay, Ray used $81,000 in 2026. And so now he doesn't have the full 15 million. He just has 14.9 plus million left. So there's no tax due if you go over it. However, you have to file that gift tax return.
Well, Nick, any other ideas that you wanted to share today before we wrap up the program?
Sure. So one of the other easy things to do if you are in a taxable estate, which probably a lot of our listeners are not, but you can also set up, they're usually referred to as intentionally defective grantor trusts. And what that means is you can set up a vehicle to make large gifts to individuals that are not spouse. And what that would allow you to do is utilize the estate tax exemption in a similar manner that we were talking about with the spouse. And so let's say you have 3 kids, you want them to, put some money aside for them and have that appreciation get out of your estate. You can set that trust up, and you can't be the trustee, but essentially you can control where your kids are not getting access to that money right away. And so that's a powerful tool if it's a taxable estate. The other thing I want to kind of touch on is for the non-taxable clients, it's still important to discuss your situation with your attorney, because there may be reasons why you want to have a continuing trust for spouse, children, grandchildren, even though it's not a dynasty trust for wealth preservation, meaning you're not trying to pass on, millions and millions of dollars. One of the things we look at is if it's, second marriage, you may not want your surviving spouse to get all of those assets and then leave those assets to their side of the family and essentially cut out, your children in my example. Or something we've come across is liability issues. And it's we're in such a litigious society. Just drive down any major road in your city and you see personal injury attorney signs on almost every billboard. I think it's national now, but we have one locally where you see him on every corner, and I think he's national. But essentially, if you keep assets in trust after you pass away, if you're the grantor and it's for the beneficiary, those assets are protected from the beneficiary's creditors. And so that's very, very important nowadays, even if we're talking about, two, three, $4 million, still a lot of money. And you don't want to have a situation where your document says goes outright to my kids, and one of those kids is going through a nasty divorce or has huge liabilities from judgments. And now your hard earned money that you worked for your whole life is not going to your kid, it's going to a creditor or potentially a divorce situation. So that's still very important to think about. And that's something we like to discuss with our clients to consider just because of those liability issues.
Nick, one thing I want to be sure to mention here at the end is to talk to people about uh, thinking about charitable distributions at the time of your trust. There are many ways to do some deferred giving. If you're charitably inclined during your lifetime, to set up, as an example, a charitable remainder trust, which can help reduce some income tax implications, or at least spread them out over a period of time if you have highly appreciated assets, yet continue to provide you with some income. But I want to stress to everybody, and again, talk with all of your individual advisors about this, but usually the best asset that you can give away at death itself are your retirement assets. Because not only are they potentially subject to estate taxes, but they're going to be subject to income taxes, not to the estate, but to the beneficiary. And many people don't realize that, if you are fortunate enough to, let's say, be leaving a child $1 million in a retirement account at your death, they have to take that money out over a 10-year period of time and exhaust it. And when they take that money out, it's going to become income taxable. So if you have a choice as to assets to give away at death to a charity, and you have retirement assets, consider using those first. But it'll be important to name them as a beneficiary of your IRA. Or your other retirement assets. Well, Nick, it's been a pleasure to be with you today. Really appreciate you coming on to Up Your Assets podcast. So my thanks to you. Just for full disclosure to everybody, Nick's firm, Johnson Pope, Boker, Ruppel, and Burns, and a firm with which I'm affiliated on a professional level. We do work together with a lot of clients. But he didn't pay to be on the show, as everybody knows, and I didn't pay him to be here on the show. So Nick, I just want to thank you a whole lot for being with us today, and thanks for all of that wonderful advice. This
My
is Ray
pleasure, Ray.
Ferrara.
Thanks for having me.
You bet. This is Ray Ferrara, and I want you to go out there and up your assets.
This has been another edition of the Up Your Assets podcast, hosted by Ray Ferrara, CFP founder and executive chair of Provise Management Group, LLC. The preceding presentation was for general information purposes only and not personalized advice. Seek out a professional before making any financial decisions. Additionally, no guests pay to be on the show or are paid to be on the show. The opinions expressed are their own and not the host's or the show.